Okay, so how many of you have ever taught a class immediately after the lunchtime? They say it's the hardest time. They say it's the hardest time. So we will disprove it. We will disprove it now. All right. So I'm going to move into a class on conflicts of interest. And again, it will be much shorter than I would normally do. So we'll only be covering certain parts of the whole topic of conflicts of interest. And you'll see, I'll tell you in advance what I'm going to do, is to give the short introductory lecture, but very short. And then I will get you guys involved in a way that's different from what I tried to do this morning with confidentiality. Okay, and then after that, we'll talk a little bit about the methods, and then we'll do a judicial impartiality, short treatment of a judicial impartiality class that I like to do. Okay, so are we ready? Today, conflicts of interest. So I have to tell you, as people who are on your way to becoming law-trained people, whether you're going to be a judge or a prosecutor or a private lawyer, conflicts of interest have become the most important topic in the law that governs lawyers worldwide. No question but that it's the most important in the US, and every time I come to Europe, I'm finding it's getting more important in Europe as well. And I see no reason why it's going to stop becoming more and more important. Why is it more important? Number one, it's more important because lawyers change careers today more than they did 25 or 30 or 50 years ago. If you had been my class in 1982, the first year I taught at a law faculty, you would have expected that when you finished law school, you would go to work for some law firm, or you would open your own office, or you would become a judge, and you would stay in that shop, in that office, until you die. That would have been your expectation. Now, it wouldn't have been 100% true. It never was 100% true. But 35 years ago, 50 years ago, it was predominantly true that people would graduate from their law school, go to work somewhere, and stay there until they died. That's not at all true today. Today, it is very common for lawyers to change the city where they practice, to change the firm that they practice in. Some of you in this room might, I'm talking with you as students now, some of you in this room might go to work for Kinsteller in Prague, or you might go to work for Clifford Chance somewhere, or you might open a small office and decide you don't like that in 5 years and have a collaboration with some other lawyers and change careers. And it's a good thing. It's not a bad thing. But it creates conflicts of interest. The fact that you work on your own for 5 years and then go to work for Kinsteller means that you know things about your prior clients that you carry in your brain with you to Kinsteller work. And if Kinsteller is opposing some of those people, there will be conflict of interest problems created that would never have been created in the old days when you would never have changed careers. So the mobility of lawyers has increased conflict of interest problems. The changes in the way that corporations function, buying, selling, reforming, selling off parts, buying parts of other corporations, that too has increased conflict of interest problems. So you may have represented, I'll call it Vericorp, some big corporation. You may have represented Vericorp for a long time, and it had 7 parts to it, 7 different smaller companies that were all part of Vericorp. And the managers of Vericorp, the owners at some point decide, we're not making money on these 3 parts anymore. We're going to sell them to some other company. And they move. Well, to the extent that you knew things about those companies as your clients, and now they may become your adversaries in different contexts, the buying and selling of corporate interests has increased conflict of interest problems to a great deal. Much, much more than it was 50 years ago. But there's one phenomenon that has increased conflict of interest problems and what they mean to lawyers, and the fact that they keep lawyers awake at night worrying about conflicts of interest more than any other phenomenon that's taken place in the last 20 or 25 or 30 years. And that is that conflict of interest problems now are no longer only the interest of a bar association policing its members, like it was at some time in the past. Today, conflicts of interest problems are raised in courts regularly, every day, in high-stakes litigation and in small, so that what's happening now is that if you are on one side of some litigation and you are on the other side of some litigation, you are trying to figure out if there are conflict of interest problems for that guy so that you can ask the judge to disqualify him, kick him out from representing his clients before that court. Bar associations were never very motivated to ferret out, to discover, to investigate conflict of interest problems. If somebody complained, okay, fine, but they were never investigators of conflict of interest. You, however, want him kicked out of the other side of that case because it helps your client, and so you are motivated, and you have a judge who will be a decision maker for you, ready, willing, and able to decide whether he has a conflict of interest or not, and if he does, he'll get kicked out. And even if the judge decides he doesn't, he'll have been disrupted to a great degree just defending his right to even stay as the lawyer in this case. The consequence of that, of this phenomenon that we call disqualification motions or disqualification requests in litigation, the phenomenon of that has meant that the frequency of conflict of interest problems actually coming to light, being litigated, being talked about, being dealt with, having consequences, has gone up 1,000 times from what it was 30 or 40 or 50 years ago. Because lawyers on each side and their clients are motivated to disrupt the other side if they can, and they do. You know American lawyers are like that, right? Are very contentious. But trust me, at least in my experience, there are plenty of European lawyers who are also just as contentious, especially when they're representing corporate interests that have a lot of money at stake in cases. And they too are filing these same kind of requests in European courts now to get the lawyers for the other side kicked out of the case. You care a lot about being kicked out of a case. Why?
Because if I'm about to be kicked off and I couldn't get any money for representing the client.
You lose your fee. That is a very big deal to you. What else might happen, and I'll tell you it does all the time, what else might happen if you are found to have this conflict of interest and kicked out of the case?
If my client is a big corporation, then probably they won't me give any other job.
Won't give you any other job, and they might even do one more thing.
Promotion to bar?
They might bar him, but they might even sue him for damages that they've already spent on his fee, that they now have to get another lawyer and start over, essentially. So it is not at all uncommon for the conflict of interest motion to result in the lawyer being kicked out of collecting that fee, destroying a client relationship, and potentially actually having money damage liability to that client for the money they've spent up to that point and will cost them in the future. So it is a huge deal. It is an extremely important thing. All right, so conflicts of interest have gotten very, very important in law practice. What are they? What are conflicts of interest? The number one thing that a lawyer owes a client, a private lawyer owes a client, is independent professional judgment. Your job is to exercise an independent brain on behalf of your client to advance their interest in lawful ways, to be sure, but independent professional judgment. A conflict of interest is anything out there that can knock your independence off, that can affect your judgment on behalf of your client in a certain way. Certainly we care about it when it affects your judgment in a way that might harm your client. So anything that affects your independent professional judgment could be a conflict of interest, and it'll have to be analyzed. We usually think of conflict of interest coming from three sources. We're not going to get time to talk about all three today, but I'll tell you what they are. Sometimes a conflict of interest comes from a third party, somebody who's not the lawyer and not the client, but puts him or herself into a position to be able to influence the judgment of the lawyer. We'll talk about how that can happen. Second kind is the lawyer's own personal interests that sometimes can get in the way. Personal family interests that can get in the way of exercising good judgment for a client. So if my client is struggling to try to be a successful, let's see, what would be a kind of restaurant in Brno, not a Czech food restaurant because there are plenty of those, but Mexican food restaurant. Are there any Mexican food restaurants? Maybe one or two, all right? Your wife owns the only successful one right now. And your client wants you to represent him as he's trying to set up a Mexican restaurant that will compete with your wife's. And you will be doing work that, if you do a good job for your client, might hurt how much money actually comes into your home, right? Through your wife's business and so forth. Your personal interests could get in the way of doing a good job for that client. That's the second category of possible interference. And we need to always watch for these. Watch for these. The third kind is the most common, much the most common, and that is multiple client conflict of interest, where one of your clients needs you to do something, and to do that well, you hurt another one. Okay? So we know, it's easy to know, we just don't represent people against each other. They're not both our clients on the same case, right? That's obvious. But there are many, many, many other times when we might represent one person, one client, and helping them hurts another. It can be very general, very, very general, and the law might say it's not enough of a conflict to worry about. Or it can get very specific, and somewhere in the middle, we have problems that are going to be disqualifying conflicts of interest. So if you represented Deutsche Bank and Raiffeisen, they are business competitors, right? I assume. Two big banks. They are business competitors, but you might be able to represent them on lots of matters where they don't actually collide with each other somehow. That might be acceptable at times. You wouldn't obviously represent them in litigation against each other, but there might be times when you could do it and it wouldn't create a problem. But on the other hand, you might, in another very different circumstance, represent a client, and one of your other clients is a witness against this client, a witness. Well, you are going to try to examine them or bring out things that are bad about this witness against your client, and they may be things that you know because of the confidential relationship you have with that person. So you will hurt that client. You will abuse their confidential information to help your other client. And either choice you make is bad. Either choice. So you have to get out. If you fail to help this client with what you know, you abuse them. If you help them with what you know that's a secret from the other one, you abuse the other one. And so multiple client conflicts can be problematic, mostly because of the confidentiality problems that come up. So how long did we decide a little bit ago confidentiality duty lasts? Forever. When does it start? When do you begin to owe confidentiality to a client, do you think?
When the client opens the door.
When the client opens the door, effectively, right? Because otherwise, right, if they didn't get to expect confidentiality when they start talking with you as a lawyer, that conversation would be very, very guarded. It would be very, very careful. and it wouldn't produce good results. So even when the client comes into your office and says, I need your help, lawyer, I just killed someone, and you look at that client and you say, I do taxes. I do tax law disputes. I don't do criminal defense. You already owed that person the duty of confidentiality not to reveal that they killed the person, right? They were a prospective, we call prospective client, and even one that never becomes a client. You owe at least some. We'll talk about how that's playing out in modern practice in a minute. All right, so let's sort of see what happens. Jan, how are you today?
Fine.
Good. So my understanding is that you have opened a small law practice, correct? Yeah. And you are doing many different kinds of work. So far, I am told, you have more time than clients. Okay? So you are looking for more clients and hope to generate more business. Okay? So a client comes to you, I'll be your client, and says, Jan, I have heard nice things about you from some friends that you do domestic relations, family cases like divorce and things, yeah? Yeah. Okay. Well, I have a problem in my family, and my wife and I, and you have to imagine for the moment, Jan, it's hard to do that I'm 24 years old. Can you do it?
I can.
You can meet the challenge? Okay.
Sure.
So I'm a young husband, and my wife and I, we want to get a divorce. We agree about everything. It should be easy. I would like you to represent me. You recognize my family name. What would be a very common, very, very common family name here?
Okay.
What would it be?
Dvořák?
Novak. Novak? Okay, I am Novak. I am, that's my name. Okay, that's my last name. You recognize it's a very common name. So you know that I have many, many, many relatives in your town, right? All right. So Jan, I'm happy. I would like for you to represent me. I think I like you a lot. I have one problem. I have very little money. What is your usual fee to do this kind of representation? You can pick any number you like that makes sense. I don't care, it doesn't matter.
Okay. Well, 10,000, yeah.
10,000 crowns or euros?
Crowns.
Crowns. Okay, crowns. All right. Okay, well that's great. I just don't have 10,000 crowns right now to pay you. Could you do this representation for me instead of 10,000 for 5,000 crowns? Would you do it?
Yes,
Okay. Why are you choosing that? We can step out of our role now for a minute. Why are you doing that?
Well, I would like to build my net of clients.
Okay.
So
I have a good name, right?
Yeah.
Maybe if you make me happy, you will get many other Novaks to come and see you. So it's okay. And you have plenty of time, right, compared to clients. So it doesn't really hurt you. At least 5,000 is better than nothing.
Sure.
Okay, so you've agreed. Thank you so much. I am very grateful. I really appreciate that. And I will be sure to tell others what a great guy you are. So see you later. I'll bring you whatever documents you need. Okay? Okay, I go. A little bit later, maybe the next day or something like that, your phone rings. You want to answer the phone?
Yep.
Hello?
Hello?
Hello, how are you, Jan?
Well, I'm fine.
Okay, good. So we don't know each other. I am father of your new client from yesterday, day before.
Oh.
Novak. My name is Novak also, as you might guess. And my son has told me, or I heard, that he is going to have you be his lawyer, right? there's one problem with this that I have, and that is my son is not worldly, sophisticated. He is young. I know you are young too, but you are a lawyer, so you are a sophisticated person. You know how the world works, and I am old. I know how the world works. I know that people get what they pay for. And he is paying you half of your normal fee, I understand. So it's a very simple matter to correct it. You should get all of your fee, and you only need to send me a statement, and I will pay the other half.
Well,
So I will send you 5,000 crowns.
No, this is not possible.
What? Why not?
Because I'm representing your son.
But you can't accept my money?
No.
What if I gave it to him to give to you?
Then it's fine.
Then it would be fine, but I don't want to do that. So it seems like the same thing to me. Why can't I just pay it to you? If you could accept it coming from him, why can't you accept it coming from me?
Because there is a representation relationship between me and your son.
That's okay. It's okay with me. You can have that relationship.
Yeah.
I don't object to it.
Fine. So,
But I will just send you, how about if I just send you the 5,000 crowns?
No,
You don't
that's
have to
not-
send me a document or anything. I will just send it to you. I can have someone bring it to you right now.
no, that's not possible.
You won't accept it under any circumstances whatsoever.
No.
Okay. Is there anyone in the room who wants to be Jan and likes money more than Jan? Anyone like money more than Jan? No one likes money here?
Me.
You like money?
Yeah.
Okay, okay. Won't anyone else do it? If not, then Vita can do it. You like money.
And I tried it before, during your first visit.
Oh, you've heard this before.
Yeah,
Oh,
so
you better
I-
not.
yes.
I thought you looked familiar. Okay, maybe you shouldn't be the one then. Anyone else likes money, will accept my money? Even on terms, some reasons, some qualifications, some anything. No one wants money? No one likes money. Okay, Vita, I guess it's you.
I'm the only attorney here, so.
You really are one. Okay, all right. So you will take, I will be father now, and I offered the same thing to you I did to Jan. You will just send a bill, or I can send you the money. No questions asked.
Oh, it will be 7,000.
Oh! It goes up.
Yeah, yeah.
Why does it go up?
Because,
I don't like that so much.
It's not very, I'm not very familiar with this, or I'm not feel very comfortable because my conscience is.
It's to make your conscience better. 2,000 crowns, does it?
Yeah.
That's enough to make your conscience better?
At least something. So.
At least it helps.
And it will help me also if your son will agree with this. So.
Oh, no. You don't want to tell him, do you? I maybe would rather we didn't tell him, because he is very naive and immature. He will not understand. You and I, we know each other better. We know the world better. He will not understand. So I would rather do it without telling him. Will you still do it? At 7,000, I didn't really want to pay extra, but 7,000 I can send you,
it's okay, but
and you will not tell
just
him.
tell me what are relationships between you and your son?
Why does that matter? The money is the same.
Because I can't do anything against.
Oh, no. I would never ask you to do anything against him.
Against him, his willingness is. Maybe he will not agree with.
I think maybe he wouldn't agree, no. I think he wouldn't agree.
And why?
He thinks he got a good deal from you, 5,000 crowns. He doesn't understand he will get better service at 10,000. I didn't know it would be 12, but he does not, he thinks he got a good deal. And you will, and you may even believe you will do a good job for him for 5,000 crowns. But I know you will not do as good a job as if I pay you 10 or 12.
Now I think about it, I don't like this disagreement.
You don't?
So I will not take it. I'm afraid of.
If I let you call him and tell him, will you do it?
Could be better.
Could be better.
Yeah.
All right, I'll let you call him and tell him. I don't really want to do it that way. I would very much prefer not. But, okay, go ahead. I'll call you back later,
Okay.
and you call him now.
Okay.
Okay, so go ahead.
So, hi, Mr. Luck. Hello. Your father called me.
What?
Your father. Your father called me just.
My father? What
Yes.
did he want?
It was good conversation. Because you wanted to pay me these 5,000 Czech crowns for the rest of my fee. And I discussed it with him, and
But
I
wait a
told
minute, you told me you would do it for 5,000. Is it?
it's okay, but if someone will offer me next time, I will at least discuss it. So I discussed it, and my decision was I will ask you what do you think about it, and if you will agree, I will accept the money.
Oh, I
If
see.
not,
So it's up to
I
me.
will think about.
It's up to me then. So, Vita, I have to tell you, makes me very, it's hard for me because I told you yesterday, I like you. I think it was really wonderful for you to offer to do this for half the price for me. And I think you will do a good job. I think you would have done a good job even for just the 5,000. So, I really feel bad if I say no. Because you are a nice guy. I feel very bad to say no to you. So maybe even if I don't want to say yes, I will say yes. Just
What's the
to
reason?
please you. Now I'm going to be worried that if I say no, maybe you don't like me so much because I kept you from getting an extra, is it 5? 1,000 extra? Did you say? Was that the number?
5,000 for you and 2,000 more from.
Oh, only 2,000.
No, five more. Together, 7 more. 7 more.
Wow. He would pay more than me? This is the better thing
Because
for you?
he loves you, so it's.
Well, he doesn't actually.
Yeah.
Honestly, he doesn't.
My question would be, what are relationships between you
It's
and
terrible.
your father? Why you don't want him to pay for you? Because it's normal that fathers and parents pay for their children. So
He says
I
to,
would pay for myself.
I try not to talk with him very often. He tries not to talk with me very often. But when we do talk, he always tells me that I am, not a good man. Always tells me I am no
Do you
good.
think that if
He also tells me I'm not a good father to my child, and he should be the father of my baby.
Do you think if I will accept the money from him, he will use it against you to push you to some
Absolutely.
situations which you don't like? Or-
Absolutely. I'm certain of it.
So in this circumstance, I will not accept it.
Yeah, but but it's up to me.
Okay, of course.
You left it up to me.
Yeah, of course.
So I have to deny you 7,000 crowns for, it feels bad to me to deny it to
It
you.
was my decision. I will not accept the extra money from your father. So, but it's up to you. If you now think that I'm not a
I see.
reliable partner
Yeah.
for your case,
Okay.
I will.
Has anybody learned from this conversation? They want to start the conversation with either father or son again? Anybody want to do it differently? What just happened? Right? Jan initially said, no, 1,000 times no, I'm not going to even do this.
I would do that differently because I think that I shall not say that I'm representing your son.
You wouldn't even tell him I'm representing. Okay, you've backed up and you're thinking you shouldn't even give him that bit of information. Okay, all right. Okay. Anybody want to pick it up anywhere you like? Either still talking to father, or now, as happened with Vita, now talking with son. Anybody? Why not? Where do you want to pick it up?
I'm a little confused about the whole situation because I'm trying to find out what my former employer would do because I used to work in a small law firm, and always the relationships in families are very complicated.
Yes, they are.
And I think that similar situation and similar conversation would lead to problems in future, even in the case that the attorney would accept extra money. It would complicate the whole case.
Okay. Okay.
Every circumstance.
Okay. So you say it would complicate.
I think
What are you afraid of?
of the damage in the relationship between the client
And the lawyer.
and the lawyer.
Okay, Jan, what were you afraid of in deciding as you did the first time around? Sure, you talked to father for a minute, but then you would not take the money.
Yeah, because it's a different relationship. These are two clients or two possible clients, and one client and one possible client, and I cannot mix it because there are many conflicts or possible conflicts.
Okay, so tell me if the father would really be your client if you took his money. Would he be your client also or not?
I don't know if he is already my client or
He's not.
if I know him.
You didn't even know him before.
I think that there would be a relationship because I would took his money
Okay.
and
Are you doing any
follow
legal
some-
work for him?
sorry.
Are you doing any legal work for him?
At least this having this money in my pocket.
Yeah, right.
So
It won't buy you a new car. That's not enough for that, I understand. But maybe a nice lunch. A little more, I'm sorry. So it would create a relationship, but is it really a client relationship? What creates a lawyer and client relationship? Is it just money? So if anybody walks up to you on the street and gives you money, are they your client just because you happen to be a lawyer?
but this father wanted wanted me to do something with this money. For example, use it for his son's work, my work for his son.
Work
So-
for his son, but not work for him.
Yeah, but it's basically work for him because this son, it's not work for that son. It's
Okay.
not in the relationship of me and his son,
Okay.
but it's work for that father.
Okay. All right, we're going to put this to the side because we got to move on a little bit. But the best argument here is that the father would never be your client because you're not agreeing to do any legal work for him. He is agreeing to pay you for legal work you do for another. So he wouldn't become your client, but I think what you're afraid of, technically he would not become your client. What you're afraid of is that he will try to influence you because he pays you.
Yeah, of course.
Right, that's what it is. So does anybody else in the room feel that? Do you feel this sense that father came, wants to pay for this work? I'm a little worried that I will be subject to his influence. Does anybody feel that at all? If you do, keep it. Remember how it feels. That feeling is the sign of a conflict of interest. Right? It's not enough to read the words in a rule. You now know the feeling of what that is. You know it in your head. You know this little worry. At least you know it's something you need to study better. Maybe it'll turn out in the end it wasn't a big worry, and it's not really a conflict of interest if the circumstances turn out okay, but you know the feeling of wanting to be on guard for a conflict of interest. It's a good thing to know how that feels. You were afraid of being influenced. Now, I'm still going to get somebody to go back and have the conversation in a different way with son in a few minutes. So think about that if anybody's starting to work up the power to do that. But in the meantime, that's what you were worried about. Do you think it would always turn out that when father, or anyone for that matter, wants to pay you to do legal work for someone else, that it is always a problem, or only sometimes a problem. Always or sometimes?
Sometimes.
Sometimes. It might be that it's perfectly fine, right? In some circumstances, it might be perfectly fine. It might be that you had this conversation with the son, and we'll change the way we approach it. It might be that you had the conversation with the son, and he would say, what a guy. My father's always looking out for me. I love that guy. I think it'd be great if you don't mind taking the other money from him. He's fantastic, and we get along great. And I'm so grateful to my father. I just have to call and thank him. It might be possible in some circumstances where it works. And I will tell you that there are some private lawyers whose every single waking moment they are being paid by somebody other than their client to do the work for their client. When I was a legal aid lawyer, when I first graduated law faculty, law school, I worked for poor people. They didn't pay me. They were qualified for legal aid. So there was a nonprofit organization set up. I was a salary employee of that nonprofit, and they paid me. Not very much, but they paid me, and I represented my clients. I was always being paid by somebody other than my client to do the work for them, constantly. And was there at least a remote possibility that this organization would try to influence the way I represented that person? I suppose. I mean, maybe if my representation of them somehow hurt one of the trustees of that organization or something, I suppose, right? It's possible at least. We think it's unlikely, but it could happen. So anytime there is a payment by someone else, there's a risk. We will evaluate it as a small one or a big one, and then figure out what to do about it. I'll give you some suggestions on that in a minute. But it's not always going to be a problem, right? There are lawyers who any of you know how lawyers who do what is called insurance defense work? Do you know how that works? You all drive car. You have insurance, car insurance, right? If your policy is anything like US ones, and I've seen some European ones, I know that some of them have the same provision in them, your car insurance policy says that if you crash and someone sues you for damages, the insurance company that protects you will hire a lawyer and pay the lawyer to represent you. Why? Because they, of course, will be the one to pay the damages. They're insuring you, at least up to your policy limit. They'll be the ones paying. So they want in that contract permission to hire and pay your lawyer. But that lawyer represents you. This is called insurance defense practice. It's very, very common practice. It's very lucrative for some lawyers. And they are being paid by somebody other than their client every day, all day. More risky than my legal aid payment from somebody else, for sure, because the insurance company might very well want to influence them. And that's the only place they're getting money from sometimes, those lawyers. So anyway, it is not always a problem. So stop for a moment. We're going to come back to the conversation. Would you design a rule to address this problem by writing it in a way that said a lawyer may never accept compensation from anyone other than a client? No, because sometimes it's fine. You were afraid of what, Jan?
I would say without permission.
Without permission, okay, we want consent of the client in this rule. What else do we want? As instruction for the lawyer, what else do we want? You were actually very sensitive to it the second time around.
Influence from other side.
Influence, for sure, but you were, even Jan was sensitive about
It is information.
information, right? So maybe we would want the rule to say, a lawyer may not accept compensation from someone other than the client unless the client gives consent, and I would add a word, informed consent, talk about that in a minute. Unless the client gives informed consent, the lawyer ensures that there will be he will accept no influence from this person who pays, and the client's information remains protected as it always was. Sounds like a pretty good rule. Because then, if all those things happen, it might facilitate the market for lawyer services in a proper way, and people other than clients could pay, like my NGO, or the insurance company, but we'd have certain places where there has to be conditions met, right? Does that sound like a good rule?
Yeah.
Okay, I haven't loaded this thing back up, but if I were running this class for my students, I would then project the rule, because that's exactly what it says. Notice what we had done as a class. We went from the circumstance that scared Jan, a fact pattern that worried him, and we built it out to the point, through our discussion, to where we could design what the rule should say. And it turns out that's exactly what the rule does say. It's really a nice moment for students to have this. They feel really empowered when they sort of have this moment where they say, yeah, I guess I could figure out what the rule ought to be from studying the circumstances and understanding how it plays out. All right, one more time. Anybody want to talk to son? So you finished the conversation with father. You said, I can't tell you whether I'll accept or not. I definitely have to talk to son, my client. I'm going to do that now. It's a lot of what Vita did, but in a different order. Anybody want to do it? Even somebody who heard it done before can do it now. So call son. You actually did it.
I did it.
You were the one who did it brilliantly.
Yeah, but I forgot the word.
Oh
What it was. Yeah, but I remembered the rule. But
Okay.
Okay. Hello.
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 Hey, how are you? It's nice to hear from you.
Yeah, I'm fine. It's great to hear you again.
Yeah.
As well. I need to tell you something. Your father called, and
oh my, really?
yeah, he did, and what he actually did, he offered me the extra money to provide me some extra money to get my full fee.
Wow.
But as I already told you, I am perfectly happy to represent you just for the money we agreed. It
Okay.
means
Okay.
5,000
Yes,
5,000
right.
crowns. So no worry. We agreed on that, and it's set.
Mm-hmm.
And I wanted you to know the information that your father called.
Oh, I appreciate
and
that. I appreciate you not keeping it a secret.
I realized that maybe accepting the money from your father could create the possibility of some influence, which will make me feel not very comfortable. That is why I didn't say yes or no, and I addressed you straight away. And I wanted to tell you that I didn't share any other information with him.
Okay.
Besides the information that I'm representing you, and that you approached to my office yesterday, and that we agree on the certain fee. I would like to...
But he already knew that, so that's okay.
He already
Okay.
knew that. He seemed to be pretty informed. So I wanted to tell you, and I want you to know that of course I'm interested in the extra money, but it will not influence any of my service, because we already agreed, and I keep my word. And if I get the extra money, I will be happy for that. But it doesn't make any difference for me as to the services provided.
Okay.
So it's up to you right now to decide what your relationship with your father is, and whether you would like him to step into your case in this way.
Okay, I want you to just rewind the last sentence or two, because up to that moment, it was perfect.
Okay. Okay.
So rewind to the point where you said, so it's up to you.
Okay.
Ask me a question before you do that. Think what you would want to know in order to help you decide if it would be a good or bad idea to take this money. What would you need to know from me?
I would like to know what your relationship with your father is, and whether.
Okay, that's good enough.
Okay.
It's terrible.
Okay.
My father and I don't like each other. He tells me I'm no good. He even probably wants to take over custody of my baby. He and I don't like each other at all. So it's amazing to me that he wants to pay you anything. I think he must have bad motives.
Okay, so now it's breaking point, and it's now it's clear that it wouldn't be a good idea to accept this money. Okay, I'm happy that you know about the situation, and I was happy to talk to you, and hope to see you soon.
So you don't want his money? No, you
No.
don't. If that's the relationship you have with your father, I don't want it. So you are not keeping it from me. I don't even want it. It would lead to problems. It's better that we just stay with the situation we agreed to and stop right there. I will be happy to call him back and tell him, no, I will not accept it because I don't want it under these circumstances. How's that feel?
Better, professional.
Yeah, so you notice all the things she did. She told me, it was like she was reading the rule, right? She told me she didn't tell him any information other than what he already knew. She wasn't going to be influenced by him. Money is money, but it's not important to her. What's important to her is the relationship that we have, and she is perfectly ready to go forward on the basis that we agreed to. And then I think if you had really been analyzing this as a lawyer, you would have been saying to yourself, I don't want the money if they don't get along. If the client thinks it's great, so fine, I'll get more money, I'm happy. It's all right to be happy if that turns out to be the case. But you don't even want that trouble yourself. And so without saying it's up to you, you first say, tell me some more about the relationship you have with your father. What's it like? That's the answer to that question is going to tell you whether you even want the money or not. And you see how it played out. I mean, obviously, you know, in another circumstance, it could easily have been that the son would say, yeah, we're great. We get along great. That would be fine. And I'd be happy for you to have the money. That might work out. But as soon as he says, we don't like each other, you know, he tells me I'm no good, now the flags are all waving, you know, this is not going to be a good situation. You don't want the money. So lawyers can be put in a position of being influenced by third parties, not another client, but somebody who, for example, wants to pay or does pay, like an insurance company, like an NGO. Whatever it happens to be that pays the lawyer's fee on behalf of a client is in a position to try to influence the lawyer. And sometimes it can work out fine, and it does most of the time, and sometimes not. So we ought to have a rule like the one you all designed that says it's possible only when, and we have these conditions to be met. So we've just studied third-party interference conflicts of interest. Okay. All right. Now, I would love to do another conflict of interest one with you, but I think now it's really a good time for us to just have a general conversation of what you're seeing in the way I'm trying to run these demonstrations. They're not full classes, obviously, but demonstrations of it. What do you see? What's happening? What am I trying to accomplish? How's it going?
You're trying to make us feel the situation. You're actually creating the lively picture of the situation and making us, you know, to get in the position and to think in the way we would think if we were in the real situation, in the real world.
Okay. So in a way, it's a kind of simulated experiential. education, right? I'm trying to put you into the mindset. What else do you see? How is this morning's different from this one? They were very different that I had you do. I think one works fine and the other works fine, but different. How did I engage you this morning with the confidentiality lesson?
It has been theoretical or just a lesson, a lecture?
Oh, the first one was just a lecture. Yeah, that was boring. That was terrible. I meant it to be terrible. I mean, there's a lot of really good information. I told you a lot of really important things in there, but it's not engaging. It doesn't kind of hold your interest and capture you. I mean, I understand that. But when we talked about confidentiality and I started asking you, have you ever felt in real life this pressure to keep confidential information? How does that feel and so forth, right? I was doing the kind of thing that we were just talking about. But even outside the role of lawyer, I was trying to capture that sensation. But then I had you do these little group, little team projects, right? How did that go?
Yeah, it was working in Paris. It was good, but still the cases, despite the fact that they were real cases, they were theoretical still. And we were discussing it from distance. But just now when we were playing the scenes together, we had to involve ourselves individually. We saw it,
Right.
theater, but we needed to think about it personally. And of course, even the merit of the case was more personal because we can imagine personally what is the situation with father and son.
Okay.
In the first part, we were all involved. It was working in pairs or in small groups.
Right.
Usually means that all were involved. In the second part, me and Jan and our colleague were involved, and others just listened. So I cannot say that it was better or worse, but it's different.
It's a
So
different way
if you
of
want to
engaging.
involve all the people, then it's better to give them all to work on at least some small piece.
Exactly. Okay. Okay. So that engaged everybody at the very same time, but maybe not as deeply. I think what I'm hearing is maybe not as deeply as the kind of role play played it out in here. Okay. What I try to do is to keep changing the game, but always in productive ways. So I don't want to keep changing it in boring ways. I don't want to keep changing it and make it worse all the time, right? But I try to make conscious decisions about what amount of lecture I'm going to do, how many kind of bits of information do you have to have as background before you can do successfully the role-playing, the fact pattern, or even the reading and interviewing each other and doing those kind of things. So I'm always trying to figure out, I'm always trying to make decisions about what teaching method will work best for what part of any particular class or any particular entire semester-long course, right? So on the confidentiality thing this morning, I actually knew I wanted to talk about each of those cases. So I had a choice. I could either have you read those decided cases. Remember, I wanted to tell you about the one with the wallet. I wanted to talk about the one where the client says I committed another crime in the past. I wanted to tell you about the one where the client is distributing a dangerous product and the lawyer has some choices to face. Those are written out. They're 100 pages long each, or 50 pages long each, those cases, the decided opinions of the courts. So one technique that American professors use a lot, and I use it some, but not as much as some of my colleagues, is they give you the case to read. And of course, first of all, if you ever give students a court opinion to read, and I know you have less reason to do it, you know, if you're teaching civil law. But if you ever do that, you have to edit it. You have to edit that opinion, or they will never make their way through it. Every U.S. law professor that does that kind of teaching, and we all do some do it exclusively, what they're giving the students is not the raw opinion straight from the court. They're giving the students an edited down opinion that helps to focus attention on the issue that they want to talk about in the class, okay? But even at that, I could have made copies and handed you out the California Supreme Court decision about the guy with the wallet, the Illinois Supreme Court decision about the dangerous product, the Illinois case and the North Carolina case about the lawyer whose client had committed another crime. I could have had you read all those and we could talk about those cases. I wanted you to learn about those examples of what happened, and my way to have you do it was by writing these little stories and getting each one of you to either be lawyer or client and learn the story from each other, and then report on it, analyze it together, work through it together. That to me is a lot more engaging than just having you read the opinions and say, okay, what did Justice so-and-so say? Right? The civil law equivalent obviously is just have them read articles and then talk about the articles and see how well they can recite the articles or something, I suppose, right? Which I expect probably nobody in this room does. Is that fair? Yeah. I mean, but that's the tradition, isn't it? I mean, the tradition is to have, and tell me if I'm wrong, because what I've seen mostly is somebody stands up in a room full of a lot of students and delivers a lecture, delivers a one-person speech to everybody to tell them about some topic, a good bit of which is just sort of telling them what's in the articles in a particular area. I don't know. Maybe that's not true anymore. It is true.
Yeah.
It still happens.
It still happens, but not as much as it used to. Is that fair?
Yeah.
Okay.
We have moved somewhere. I guess it was your lecture in Ormond that you remind us of a situation in Thailand or Indonesia. And you have exercise, means you tell the student the story, and one student raises his hand and says, well, it's article 455.
Yeah.
So this is what we are now doing in our exercises.
Oh, okay, okay. So they have to have read or understood the articles and then pick out the right one.
Yeah.
Okay, all right. Which is better than just giving them a speech about it,
Yeah.
right? Much better than giving them a speech about it. Okay, all right. That's good to know. That's good to know. So what else? I don't know. What else happened? Do you have any sensation of what else I was trying to accomplish or what was going on? Either not in the lecture this morning, but in the parts after that.
During the role playing, we were forced to formulate the direct speech. We didn't say, oh, I would say something like this and this. We had to say it, and we heard how it sounds, and sometimes it sounded terrible.
Yeah, is that harder to do, to actually talk to someone rather than say what I would talk about? Much harder, but it is what you have to do in life, right? So you're getting practice at that. In the session where I was working with Jan and then Vita and so forth, other people weren't talking. How did it feel when you weren't talking? Just okay. It was.
You can focus.
You were focused still. Okay, so you were more focused even though you weren't talking.
Yeah, because I was focused on.
Yeah, you were still kind of listening to the back and forth. Was anybody in the room kind of saying to yourself, oh, I wouldn't do that. I would do it differently. I would say it differently. I would answer it that way. Oh, here's what's going on with how Jan is answering that. I hope so, right? I mean, definitely what I'm trying to do is to have everybody at least thinking, even if they're not talking, when those kind of things are going on, or at least most people, right? There are always a certain number of people who maybe just traveled 24 hours yesterday, like me. There are certain people in your class that it's harder for them to focus because of other things going on in their life, right? I mean, no question about it, right? If you have enough students, you get a certain amount. And you maybe nobody can reach all of them, but you can get most of them. Okay, anything else? Do you all feel like you do or can do some of these things in your classes? Yeah? Yeah? Okay. Do you think it'll be fun?
I think so.
Yeah, I mean, does it seem like I have fun? Definitely I have fun. I mean, I can't tell you how many times, in a multiple sense, right, like in math, how many times more I enjoy doing what I just did than what I did first thing this morning and just talk at you for 30 minutes or 40 minutes. I mean, that's not fun for me. And I think it's not nearly as good, you know, for the students. Okay. All right, you want to try some judicial stuff? Yeah. So I've got to get this up and running so that I can show you some slides, but I can talk while I'm doing it, so I don't. What do I do with my, there it is. So this is actually a class that I have done. Yeah, I've got to wake that up again, don't I? This is a class that I have done I do this class for my students all the time. But I also do this one for judges. And I can only tell you that it is different when you're doing this with judges as opposed to students. Because they are living this stuff, right? So I've done this, you know, a version of this class with my students in China and the US and Slovakia and Spain. And I've done part of it as a demonstration in Olomouc in the past, part of this one. But I've also done it in, you know, kind of rule of law projects that I've worked on in Kosovo and Indonesia and Slovakia with actual judges. Which audience do you think is easier, students or judges?
Students.
Students, no question about it. The judges can be a little bit testy. So I'll show you that I actually build something into a part of this class that is meant to get them to like me, right? I cannot say how important it is, especially with a tough audience of some kind. You're not a tough audience, but especially with a tough audience of some kind, whether it's a group of board students or it's a group of judges or lawyers that I'm talking with about a topic they maybe don't want to talk about. It is so important that they like you. If you can actually get them to feel like you're an okay person, you're not really bad, or completely bad, then you have a chance. So maybe the toughest were a series of days that I spent with Slovak judges last year, talking with them about the possibility that they were considering at the time of adopting a code of judicial conduct. Right? They were talking about it at the time, and there were competing codes, one that I liked very much, one that I didn't like very much. And that was really tough, talking with them about that. All right, so I'm not going to do the whole wind-up and lecture part of this. I'm going to kind of tell you what it would be, and then I'm going to jump straight to a few hypotheticals that I do. But what I talk about are the concepts of judicial independence and judicial impartiality. And I try to explain through a whole bunch of slides, but slides that don't say too much. So how many of you use PowerPoints or other kind of presentation? A lot of you? Okay. I hope and I expect that nobody in this room is the kind of person that has a slide with language that completely covers the screen, that in effect you just stand up and read. Okay, but you've seen presentations like that, haven't you? They're bad. That's really bad. Just reading somebody's PowerPoint while I read somebody's PowerPoint, listen to them read it to me. That's pretty deadly, right? That's pretty deadly. So I'm sure nobody in this room is going to ever do that. I've seen plenty of those too. I basically try to distinguish impartiality and independence in this way. Impartiality to me is a much broader topic than independence. They're both extremely important, but impartiality includes independence in this way. Impartiality is just about having a neutral mind, being open, considering all arguments, not prejudging, not being subject to influence by anybody that's not supposed to be influencing you. Yes, the lawyers should get up and make their arguments, and they might influence you. That's their job. It's okay. But influence you with the power of ideas, not with their favoritism, their money, their family relation, none of those things, right? That's fine to be influenced by the power of ideas. Impartiality is about resisting inappropriate influences from all sources. Independence is about trying to insulate judges in making their decisions from influence by the state, by the government in one way or another. Again, except for the power of the ideas that are expressed by government in one way or another. So when we have, as in most countries that have joined the EU in the last 20 years or so, but not in Czech Republic, when we have a judicial council, it is set up so that it will get to have most of the power over things that happen within the judiciary. Who gets to be a judge? When will there be judicial discipline against the judge's misconduct? How will judges be paid? Where will they be assigned to their work? Where will cases be assigned to which judges, and so on and so forth? Judicial councils, when they have full-blown powers, like the biggest powers that they have in Slovakia and Poland and Hungary, they have all those powers. You know, in a group of typically 9 judges or 15 judges or 18 judges, they are deciding all of those questions in one way or another. They have the power over it. That's great in that it insulates them from influence by government actors. They shouldn't be subject to influence in their daily decisions by government actors, but sometimes there's too much independence, and I'll talk about that another time. But independence is a subset of impartiality. It's the structures that we create to try to keep judges from being subject to influence by government actors, state actors, as opposed to private people who want to bribe a judge or anybody else who's trying to influence a judge. So independence and impartiality. Everywhere on earth except one place that I work, impartiality is almost synonymous with judging. It is what a judge is. It's a non-influenceable, it's a neutral decision maker. That's what a judge is. Anybody guess where I work that impartiality is? It's in their code, but it's not really what's meant for what judges need to do, at least in certain kinds of cases. Any guesses? No guesses. China. So in China, it is still true that a lot of the judges are not law-trained people. That used to be true here too. I've been told by some folks who were here a long time ago. Judges didn't need to be law-trained people. They were functionaries of the state, basically. And in China, that's still true. Their role is to advance the interest of the state. It's not really to be impartial. It's to advance the interest of the state and the party. And so China is the one place where this isn't true, but that I've worked, but every place else it is. All right, so I'm going to kind of jump ahead of a bunch of this stuff. I typically talk about different formulas for getting independence. So say a word about what impartiality means in terms of culture, right? Certainly impartiality can mean different things in different cultures. There's no question about that. I was working with judges in Indonesia, and in Jakarta, big city, 22 million people, lots of things going on, right? A judge would be subject to influence by a party who would meet with the judge privately and give the judge a gift of a Rolex watch. That's a serious gift. Anybody here have a Rolex watch? Not me. Anyway, that's a big gift. And no question but that its intention is to influence the judge's decision. When you make that kind of gift, and you are somebody who might or might not, even at that moment, you might be a party to some matter in front of the judge. But I also wound up working with judges in Indonesia who were in very, very small villages. Very small villages. And they asked me, they said, we were talking about gift giving and what judges should be allowed to accept or not allowed to accept, and what they should have to report. If they are allowed to accept it, should there be a reporting system so that everybody can see what the judge got and from whom, so they know when to try to get the judge disqualified or things. So there are systems that say don't accept anything. There are systems that say don't accept anything above a certain amount. And then there are systems that say don't accept anything above that amount. But between this and this amount, it's okay as normal gifting. Like if I'm a lawyer in that judge's court, but I'm also that, I've been that judge's friend for 25 years, and the judge gets married. Should I be allowed to give him a wedding present? Right? There's systems that say, yes, I'm allowed to give him a wedding present if it's a normal kind of wedding present. I can't give him, a jet airplane or something. But he has to report it, right? The judge has to, report that as a list of things and amounts and all the rest that he gets every year so that you can keep track. So there are all these different systems in different parts of the world. But these rural judges in Indonesia said to me, we're afraid that we're going to have a system where you can't accept anything. And I said, okay, so tell me what the problem is. And they said, in my village, the judge might say, I'm a very, very honored and important person. I am the resolver of disputes among the villagers. And I do it in a court, right? But they're accustomed to having an elder in their society who decided these things and helped them work through things. And this is a great honored person. And so they always give me a gift when they come to my court. It might be a chicken. It might be a small bag of rice. But it's part of the culture that they give me a gift. And I kind of went, oh man, never thought about this before, right? So what am I going to do? So I sort of backed up, and like you all try to do, I'm sure, and I should do, I try to go back to first principles. Right? I try to go back and say to myself, all right, why do we prohibit or even require reporting of gifts? Why? I got to answer those questions in their context. And I said, number one, is this bag of rice or chicken something that could cause a judge to be influenced in their decision-making process? Is that possible? They said, no, of course not. I mean, in fact, people would think I was crazy if I didn't accept it. They would think it was a problem with me. I said, okay, number two, if learned about by a member of the public, would this gift cause them to mistrust justice? Right? That's the other reason that we prohibit judges from getting gifts. Being influenced or running down public opinion of justice. And here they said to me, no, this would not, my receipt of the rice will not cause anybody to think anything bad about justice. Quite the contrary. If I failed to take the rice, they would no longer trust me or believe in me as the judge in their village. I said, okay, then we need a rule that says you need to be allowed to take the rice and the chicken. And we'll have to figure out some way of articulating that in a rule that sets some, limit. And I talked with them about the judges, their counterparts in Jakarta who were getting Rolex watches and airline tickets. And they understood fully that was inappropriate. So impartiality, whatever it happens to be, has something to do with the culture that you happen to be in, and it's important to understand all that. But there are certain things that kind of cut across it. So I'm going to try what are very simple appearing hypotheticals with you. Here we are, we've got a judge who's hearing cases regarding bank, capital B bank, whatever it is, I don't care. And the judge's son currently has a loan application pending at the bank. Should the son be prohibited from applying for a loan at the bank? Is that a problem?
I think it's son's problem.
So should the judge have to tell son, you cannot apply for a loan at the bank? The bank is a litigant in my court all the time. I mean, they come, you know, they're a bank. They're an institution in my town. They're always in my court for one thing or another. No, shouldn't be a problem. Okay. This is the thing I put in that gets the judges to like me, or give me a chance at least. Okay. I agree. As it reads here, it is not a problem. It is not a problem. Judges have to be able to live. Their children and family have to be able to live in their community, right? What if in place of bank it was only market in town for food? Does the judge have to starve because, you know, the judge can't do business with some, you know, market that does, you know, comes to the court, or the judge's family? Of course not. When I go to speak with judges, not students, when I go to speak with judges or I go to speak with lawyers, they start from the assumption that because I'm a lawyer conduct guy or a judicial conduct guy, that every one of my hypotheticals I think is bad. I think the person has done wrong in it. So I want the first one to be very simple, and I think it's okay. So usually what happens, I'm just kind of telling you a story now about how the teaching goes. Usually what happens when I'm doing this one with judges, they start out saying, what do you mean? Why can't the son have that application at the bank? Why? Why not? What's wrong with that? And I say, I agree with you. And they all go, oh. Okay. All right. This guy doesn't think everything we do is bad. Right? So I say to them, you're right. What could happen? Add one fact that would make it a problem for the judge's impartiality. Add one fact, and you'll be able to do what the judges do, and you'll think of 7 or 8 different facts, right? But any one, just add one fact.
If the father should pay, the son is not able to pay afterwards.
And then what?
So then he wouldn't be involved.
Okay, he might have impartiality problems then if it's a case about his son and the bank's trying to foreclose on the loan. Sure. What else? What other really simple things would change this little hypothetical just by adding a fact to make it problematic?
Well, if somebody from the bank approached the judge
and said, we're giving your son a loan, would you help us with this? Yeah, that's obvious. What more subtle things? Somewhat more subtle than actually going to the judge and say, we want you to do us a favor.
The loan is too lucrative, according to another ones that bank usually provides.
It's on different terms.
Yeah.
It's on easier terms for the judge's son than it would be for the next person who walks into the bank, right? They've given him a lower interest rate. They've qualified him to borrow more money than he actually qualifies to borrow. Right? He maybe is qualified to borrow, 5,000 euros, but he wants to buy a car that's 10,000 euros, and they loan him the money anyway, right? So terms that are more favorable for the judge's son than the ordinary person suddenly make this a problem for the judge's impartiality in all of his cases with the bank. They are creating a situation that makes the judge feel obligation to them by being extra nice to the son. Okay? So we could think of a lot more, but all these sorts of things, especially things that the bank does to try to essentially create favor with the judge, turn this into a problem. So what I say to the judges, or my students for that matter, when they do this, I say, what we've just done is very important. Here's a great line, it's good to be here. I gave you the hypothetical, and we all together agreed that it was on the proper side of the line, right? Then you added a fact, you added a fact, you added a fact that moved us over here. And understanding why that fact, that fact, that fact moved it from here to here is understanding where the line is and what it means. That's what we just did. We just saw how that fact changes it from proper to improper, and I would spend a little time. We're not going to do it today because we're going to run short. I would talk about a little, well, let's do it. Hell with it. Sorry about that. Why did that make it change? Why did that fact that we added make it change? Why did changing the terms for the son?
Well, because it seems to the public quite different. Not to the judge, for example, but objectively to the others, it seems like there has been something is wrong here.
Yeah, certainly anyone who is in that judge's court from that point on who learns of this, anyone who learns of it and is in that judge's court against bank, they don't trust. They have doubt. And public, I mean, and then the larger question, the kind of one that's out there, especially in countries that are trying to build up public trust in their judiciary and need to build up public trust in their judiciary. Every one of these events that take place causes the public to talk and talk and talk, and down comes the trust in the judges, and down comes the trust in judiciary, and people try to stop going to court. If they can, they find other ways to solve their problems, which is not always so productive. So it's because it causes people to mistrust what's happening. They see the situation, and it is what functions in our brain that says to us, something unfair is going on here, and I don't trust that I'm getting a fair treatment in this case, right? Every time there is some ruling in favor of the bank from that point on by this judge, anybody who knows what has happened with the judge's son and the bank will mistrust it, will think about it twice. That's what made it go from here to here. Now, the words of the rules usually say something like, a judge should disqualify himself, and here the judge would say, I'm disqualified from working on cases for the bank, which is not a good thing for the justice system in a town. But if the judge had to do that, it's because a reasonable person would doubt the impartiality of the judge. That's usually the language that we see in judicial codes and law on judges and things of that nature. And here it is, right? Now, we distinguish between things that people unreasonably regard as a problem with a judge, right? If a person said the judge's son should not even be allowed to walk in the bank, we would say, okay, you mistrust the judge, but you're not reasonable about it. That's not the way you should think about this, and we're not going to adjust the judge's life or the family's life for that reason. But the special terms for the son would cause a reasonable person to doubt justice, and that's what matters for impartiality. All right, let's take a look at this one. In the judge's court right now, there's this case involving an herbal remedy for pain relief. Can you get anything like that here? Go to the pharmacy, or maybe even I don't know, what other kind of store would you go to get some kind of herbal remedy that says it relieves pain?
It's a process, I think.
Okay. The plaintiff is claiming in this case in the judge's court that his child used the product and became extremely sick and go to the hospital. Now, naturally, there's going to need to be some medical testimony or evidence to connect it. I understand that. But judge's spouse used the same product 6 months ago and became very sick. Is that a problem for the judge's impartiality? Yes? You say yes? Anybody else say yes? Yes? Yes, yes, yes. Okay. We can agree. Most of us will agree this is a problem. Now the question is why? And as simple as this hypothetical is, very, very simple, we will actually find together as a group the reasons that cause judges to have impartiality problems, all hidden in here. Very simple place. Why does this threaten the judge's impartiality? I want you to come up with at least 3 reasons. But anybody can come up with one, and we'll start there.
The judge has an opinion on something that is to be proven.
The judge
Or he has opinion.
already thinks he knows the facts. Already thinks he knows what the truth is. That's number 1. We want judges who do not already think they know the truth. To be impartial, you have to be open to the factual presentations of both sides. And a judge who thinks he already knows what the true facts are, it's difficult for the judge to do that. It is a threat to the judge's impartiality. Okay, number 1. Number 2, what's the second one?
Yes, interesting.
What kind of interest? Say what the interest is.
So his wife can get damages.
Yeah, maybe if the judge is correct, if the judge rules a particular way against the company that makes this remedy, it may lay the groundwork for his wife to have a stronger claim. They may even be willing to settle her claim at a higher amount just to get rid of it. But the judge has a personal, a family financial stake in the outcome. We don't want judges to rule on cases when they have a personal financial stake in the outcome. I'll tell you that there's this classic case that's taught all the time in the United States. It's from the 1920s, a really long time ago. It used to be common at that time for a judge in a very small town, and judges in very small towns in rural parts of the United States, that their pay, their salary actually came from a percentage of the traffic fines that they imposed on people. So if you would get a traffic ticket in this town and the judge ruled against you, said, yes, you were going too fast, the judge would get a portion of the fine. Now to us, that's all really pretty obvious that that's a problem, right? That judge has a big financial stake in the outcome of those cases, but it took a United States Supreme Court ruling to say that no judge should ever be allowed to decide a case when the judge has a personal financial stake in the outcome, except, we would say, for a de minimis stake in the outcome. So what do I mean? I mean, you know what I mean by that. It's very, very small, right? Very small financial stake. How could it happen that a judge would have such a small financial stake we wouldn't care? Can you think of an example? Let's say that a judge has a retirement fund, right? A private retirement fund, in addition to his, possible state pension. He owns very, very, very small amounts, because that's the way these funds are set up. You buy kind of a share of the fund, and the fund is set up so that each person owns this much of 200 different companies. This much. And one of those companies is in the judge's court. They're being sued for damages. In theory, at least, it might cost the judge 1 cent if the judge rules one way or the other. We don't care. Okay, we will allow that to happen. We don't care because it's we say, de minimis financial stake in the outcome. And to prohibit judges from those kind of cases would effectively be like the first example, prohibiting the judge from sort of living, from buying a share of any sort of retirement money, which we wouldn't want to prohibit them from doing. All right. Judge who thinks he already knows the facts. Judge who has a personal financial stake in the outcome. One more. One more.
Well, he can have personal, emotional state towards the company.
Exactly. He's likely to dislike these people before this case even starts, isn't he? I mean, I don't know how many of you are married, but, you know, if somebody made my wife sick, I would be angry at them. I would be really angry at them. You know, I don't know if I would sue them or not. It would depend on lots of things. I probably wouldn't. But I wouldn't like those people. Right? I love my wife. Why would I want somebody to hurt her? So this judge probably starts the case with a personal dislike for the maker of this product, for one of the parties in the case. So this is actually a tricky one for impartiality. Because do you suppose it happens that during a case, there are times when judges develop dislike for one side or the other? Could it happen? Yeah, all the time, right? If the parties behave badly in the middle of the court, the judge starts not liking them so much. So should we disqualify a judge every time a party behaves badly in his court or her court? No, probably not. So most systems have drawn the line at the moment a case begins. The judge who has a significant personal dislike for a party before the case starts should disqualify herself. The judge who develops dislike during the case doesn't need to. That is generally where the line is drawn in judicial ethics systems. Okay? All right. So what's important about this hypothetical? It was designed so that we would ferret out the causes of impartiality. So it's pretty quick and easy to look at this one and say, something's wrong. Something's wrong. But that's not enough. That's never enough to do serious analysis. We have to get underneath that and figure out what is making us feel something's wrong. And getting underneath it is about experiencing this discussion of what can cause the judge's impartiality to be threatened. And there are at least these three sources in here. Okay? All right. Any? Okay. Shall we do this one? Yeah, I think so. Would you be willing to play a part in a play if I describe it to you over here? And Vita, maybe would you be willing to be the judge in a one-act play? Okay. I have to tell you your role. I didn't have a chance to do it in advance of the day, so I apologize to others. Honestly, I would never do this during one of my own classes because everybody else is just sitting around wondering what to do now. So I would have prepared somebody before. Vita, all you need to know is you'll sit in the front and you will imagine for all of us, with all of us, that you are sitting outside on a beautiful day at your favorite terrace or cafe, okay? And, oh sure, why don't we do it over here? That's great. That's a good idea. I didn't think of that. And someone will approach you and you sort of recognize her, but you're not sure. But when she describes who she is, you will know who she is. Okay, that's enough. And you're a judge. Okay. So why don't you come over here to your...
You're free to do anything.
Oh, yeah. So you're over here at your cafe. Okay, everybody, let's see what happens.
Hello, Judge. It's so nice to see you.
Yeah.
I haven't met you for a year now. Do you remember me?
Oh,
We were on a trip to Croatia last
oh
year.
yes, yes.
I'm Mrs. Jones. Nice
Oh,
to meet you.
nice to meet you.
Well, I wanted to talk to you for a while now. It's a beautiful day, isn't it?
Yeah, that's
Yeah,
great.
yeah.
You want coffee?
Yeah, okay. Yeah, thank you. You know, I wanted to say that, to tell you that the trip was so good. Thanks to you, many people told me that you were the best person on the trip. You were so friendly, and it's always good to know that your friends and the people around you appreciate your character.
You need something?
Of course not. So, how are you?
I'm fine. Yes.
Are you going to go with us to another trip, or?
Yeah, I would like to because I like it very much. So probably yes. We'll see you again. It's good.
Nice to hear. And do you know that your daughter applied for a job in my office?
No, what's the office? Sorry, I forgot.
I'm organizing the trips.
Oh, for a trip, okay. Yes, she told me, but we don't need every time, so...
She seems to be very nice. I'm sure that she will be a good employee for me. Is she interested?
She's great, so we will be satisfied. Okay.
You are very, very lucky that your daughter is so nice and clever. My son is also very nice and clever, but unfortunately, he just broke in business. He's a very nice boy. Unfortunately, his friends are not so nice people.
Yeah,
I'm just wondering if maybe I can do something for your daughter. I can give her a better terms.
you can, of course, anytime.
I'm just wondering if it can help my son in his case.
No, it can't. Sorry, I'll pay.
You want the bill?
Yeah.
Okay, I will do the way it is usually for me in Czech Republic. I will be back with your bill in 20 minutes.
So there's an option how I can make things better for
And your son's case will be in our court, or?
I'm not sure yet. Maybe I'm just looking for some advice just now because it's still at the beginning of the case.
Sorry, I can't tell you anything. I can't help you. So I will leave now and wait for the later. Somewhere.
Okay, so you're going to leave.
Yeah.
You're just going to get up and leave.
Yeah.
Okay. All right. Okay. That's it. We didn't know how Vita would react when he was approached this way, so we found out. Right? What did you think? How did he do as a judge? Was he good judge, a bad judge? Should he do something different? Would any of you have done it differently?
I maybe went a bit far and maybe give advice. For example, like I know this lawyer and he's good, for example, in criminal law, or he's specialized in insolvency. Go and see his advice.
Okay.
This is the only thing that I can tell you. For
Okay.
example, that would be like just a bit more. But
is there any circumstance under which even that would create some problem?
Maybe in the case that the lawyer would be a friend of the judge.
Okay, but that could be a problem, but Vita was not sure if the case was in his court or not, and you were not sure. I didn't tell you that part, I'm sorry. It is in his court. But if you recommended the lawyer, and it turns out the case is actually in your court, in front of you, does that sound troubling in any way? I've now recommended the lawyer who will argue to me on behalf of your son, who I recommended. Okay. Anybody else would do it any differently, or do you think Vita did it just so well? Just right. You left.
I left.
Weren't you very rude?
Yeah, I was, of course.
You were rude.
Yeah.
Why do we want judges who are rude? Or is that necessary?
No, it's not, it was not.
It was not necessary? Oh, okay. Okay.
I made, of course, I could explain a little bit why I should leave, or I stop the conversation, and not only stop the conversation, but also to go out, because some explanation why it's not possible for me to continue with conversation, but I think also I had to leave.
You had to leave.
Yeah.
This was a good thing to do.
Not to be seen with the person who tried to
that too.
influence me, and
So how do all of you predict that real judges act when I do this? I do this with real judges, same one. How do you think they act?
They consult the situation and try to explain the matter and the law, and to...
Do you think they stay longer than Vita stayed, or no? Almost all of them stay much longer than Vita. So you cut off our conversation a little bit because you did such a good thing to leave. Most of the judges that I do this with, and my students, to be honest with you, they stay longer. They want to chat. They want to explain more about why they're not allowed to do things. They want to explain more about what a judge does. They want, all those things. During which time, of course, mom keeps telling over and over and over again what a good boy her son is and why he's not guilty of the crime, and on and on and on. Right? Okay. So I want to explore two things. So you did a great job as a judge, right? Way better than judges do, frankly. If I'm doing this with judges, what always happens every single time I've done it is the first one stays a very long time. And we talk a little bit, and then some other judge will raise his or her hand and say, "Can I try it?" And I say, "Well, you already know what's going to happen, but sure, let's watch. Let's see what happens." They go up and they leave. Right? They go up and they kind of, they leave. And sometimes the crowd of judges applauds for them because they left. Right? Other times, they criticize that person and say, judges can't just get up and walk away from someone. They're rude. In our culture, you can't be that rude to people. It's not possible. Right? So it gets different kinds of reactions. Two things. In your role, why do you think you, mom, approach the judge here instead of at the court, or come to the office and go through the full steps? And
because I didn't want to make it publicly known. I wanted to talk to the judge in private.
And why did you want to talk to the judge in private? Not just to not be embarrassed, but some other reason, right?
I think that people who are behaving with play know that it's not correct.
Oh, okay, okay. Okay, so it would have been better even for you if you could have caught Judge not on a beautiful day outdoors when everybody could see, but on a, you know, in a dark alley somewhere along.
Not really, because in usual circumstances, well, in some daily life situation, we can pretend that it's totally normal situation.
Got it.
We are just talking about our shared experience.
Okay.
During the
So it would look
vacation.
normal to people, maybe. Okay. Anybody else? Why do you think Mom preferred to approach Judge at the cafe? It's a very simple answer, I think. Why did she prefer to approach him here than approach him at the court?
Because he feels more like normal human, whereas in the court building he feels more like holding the office, should behave professionally. It's connected to the place and
Okay.
to his professionality.
And therefore, what would be true about her plea or request or approach to him? What would be true about it?
That it's obvious that she's trying to influence him.
Yes? Okay.
It's more personal. And for
It's more personal.
for the judge or for the person, it's much harder to reject or to say no.
Okay, so I think everybody's saying kind of an upside down version of what I was thinking of, and that is she thinks she'll have more influence here than in the court.
Yes.
And she's trying to use influence, right? She thinks she will have more influence here than she will if she does it through the official ways. That's why we require it to be done through the official ways, right? To allow others to be part and hear what you say to the judge. You know, it's all of those things. To make it official is to make it open, to make it more transparent to the other side in the case, which in this one is probably probably a prosecutor, but it might also be the owner of that business. You know, the owner of that business might very well wind up being a party in this matter as well, seeking damages, right? They can do that. So I think the reason this person approached here, and ought to be a lesson for all judges in terms of their impartiality, she approached here because this had a better chance of influencing his decision, right? Getting his out. Vita said something about not wanting to be seen. He wanted to get out of there. What would you do about that as a judge when you got up from there? What might be the first thing you would want to do when you got back to the court?
To report it.
Exactly.
To notice something.
Exactly. Will you be in a better position later if somebody questions? You know, who knows? Was the owner of the business, was a prosecutor, some administrative person in the prosecutor's office that was in the cafe or saw you or walked by or whatever, and goes to say to someone, the judge was sitting down with the mother of that defendant, right? Having a conversation. I didn't hear them, but, or maybe they did hear them, and it's even worse, right? You would definitely be better off in terms of protecting justice and yourself, not only justice but yourself, if you're the first one to go back and report it. And I usually say maybe there's somebody in your court president's office or something like that that would be the proper person to go to. However, I have to tell you, when I suggest such a thing to judges who are in certain kinds of judicial systems, they think I am out of my mind. That you would ever tell the court president, who's actually the corrupt one, they say, in their court, that I was approached by, this person and offered something. They would want to know why you didn't accept the bribe. They would want to know how much they get. So they would not be the right one to report it to, some tell me. But reporting it somehow is probably the right thing to do. And even in a system where that's not so good, documenting it, going back and writing a note that can be put in a file, have it dated, have somebody witness the date on which you're putting it in there, a neutral person, so that you will have that kind of protection. Okay. So what happened here with this role play? Having two people walk up in the front of the room and do something like that, does that sound useful or no? What would make it bad? There are people I've seen try to use this technique and it doesn't work at all. Can you imagine a setting where it wouldn't work?
When those people feel too stressed to understand the task and they are not...
Those two.
No, I'm not criticizing
or
anything.
No, I mean the two you choose.
Yeah, the two you choose, it's too stressing for them, so they will not get anything out of that, and they don't perform well enough for the rest of the audience to understand what was
That's an excellent point. From a teaching method perspective, is there anything you can do to help, not perfectly, but help guard against that?
Make them prepared.
Okay, make them prepared for sure. What else? There's one other part of this that I do sometimes, depending on the group I'm in.
You can ask for volunteers.
Ask for volunteers, so you're sure they'll be comfortable. You can play one of the roles yourself, right? That allows you to have a sense of the other person that you're up there with and do the role in a way that feels a little bit less threatening to them, makes them at ease. So you can be part of that, and you completely take out of the equation one of the two people at least from being nervous, from being upset, from getting their story wrong, from all those kind of things. So depending on the group I'm with, sometimes I will play one of the roles. Now, I never play the judge in this one, so I have to be dad. And it actually, tell me if you think this is wrong, but it helps to have them be of opposite genders in this one. There is especially if the judge is a man, it's sort of like she flatters him a little bit, and people usually in the audience kind of think, yeah, I can see that happening, right? I can see that reaction from a man, from a judge, right? I don't know, maybe I'm wrong about that. So one of the things I do to try to take that part out of it sometimes is to play one of them myself, right? And certainly trying to pick somebody that you have confidence in your class, that so far in the class has been comfortable in those, in a situation, is a good idea. What else could make it go really wrong? So I've seen people try something like this, but it's a little different, where all the students are going to do interviews of a client, let's say, or something like that, kind of like I had you do this morning with the confidentiality ones. But instead of having you do it to yourselves, have each pair come up in turn and do it in front of the whole group. How long do you think that holds the attention of the whole group? Not very long. Not very long. So I've seen people try to have like 6 different pairs come up and do their interview for the whole group to see. It doesn't work so well. They wind up, you wind up with everybody else in the room with nothing to do, and they start to fall off. Now, it's possible if you decide to do that technique and have people come up in the room, not something they don't know that's going to happen, that's kind of exciting and interesting and fun to watch and everything, but you have to give them a job. You have to give everybody in the room a job to do. They have to be writing a report. They have to be answering a given set of questions that you give them in advance so that they know they will be ready to participate at the end of it, or even turn in their answers to these questions from watching. It's the only way that I've found to keep the rest of the group involved and engaged. Okay. Questions, comments? Anything at all? This is usually the end of I've built up to it for a longer time, but this is usually the last part of this impartiality presentation that I do to judges, for judges. Anybody? Questions, comments? Or you just want to get out and enjoy the nice day? That's okay.
We have have still time to spend because.
Oh, we did. I thought we were okay. I thought it was supposed to end at 3. Sorry.
It depends on the participants.
Okay.
We can spend 20 minutes. Continue.
I'm happy to. I don't have like a 20-minute bit to do. So if people have questions, comments, things they want to talk about, so I'm open to talk about anything. Anything that you would be interested to talk about, I'm willing to talk about. Maybe with the exception of Donald Trump. Although even that I'll talk about if you force me.
Okay,
Yeah, please.
Go to the very beginning.
Yeah.
I would just like to ask, is there some kind of psychological examination of those who in the US want to become judges or some other legal profession?
No. So in the US, we really do act as if we have a single legal profession, that judges, prosecutors, lawyers, private lawyers, corporation lawyers, government lawyers are all part of this thing. They all take the same degree, and they don't go to a specialized course after their degree to be a judge or to be a prosecutor. I know it's usual in most of the world that either during the normal legal education or when, maybe the LLB ends or something like that, it's normal for judges to go over here and private lawyers go over here and prosecutors go over there, right? Is that how it happens here? Yeah, that's a very normal pattern. We don't do it that way. So everybody gets a JD. It's a graduate law degree, as you probably know. Everybody gets a JD. Everybody passes the same examination, bar examination, in their state at least. And at that point, technically, everybody who passes it and has done everything else they're supposed to do is licensed to practice law. They all have the same license. At that point, if you decided you wanted to be a prosecutor, you would apply for a job in a prosecution service in your county or your city or the state level or whatever it would happen to be. You would just be applying for a job to do that. If you wanted to be a judge, it would depend on the state you happen to live in, or if you wanted to be a federal judge. If you wanted to be a federal judge, you would never, under any circumstances, get to do that straight out of law school, for sure, right? You have to have a lot of experience. It's a position that you get appointed to, nominated for, really, by the president, the United States president, and you get approved of by the United States Senate, 100 legislators, 2 from each state. Some of you maybe know that we're having a big controversy about that right now. You know this? So we had one of our Supreme Court justices died recently, Scalia, very famous one, and the normal thing is for the president to nominate somebody and the Senate to consider that person, but the Senate right now is saying we won't consider anybody that President Obama suggests. So he's gone ahead. He did. I don't need to reveal my politics one way or the other, probably, but he's done something brilliant. He has nominated somebody that is not like ideologically close to him, Obama. He has nominated somebody that is like smack in the middle by everybody's estimation, who knows his judicial record and his mindset and everything else in terms of his ideology. This is a judge who's kind of hard to object to, right? So it makes the Republicans in the Senate look silly to say we don't care who it is, we won't even talk to him, for example, right? So back to your question. I'm sorry. If you wanted to be a state court judge, in theory at least, you could do it straight out of law school. It doesn't happen very often. In some of our states, the governor of the state, so the executive power in the state, nominates the judges, and they are approved by the state legislature, sort of like the federal system does it. In many of our states, I can tell you historically how this happened if you're interested, judges are elected like politicians are. They are elected by popular vote. It's very interesting historically how that happened. It produces some probably good things and a lot of really bad things, right? So you wouldn't go to any special school, you wouldn't get any special testing. You stand for election if you're in one of those states, or you create a record that would convince a governor to appoint you in another. Yeah. I think there are good and bad in that. Yeah. The good for me is that judges are lawyers. They have some understanding usually. They've practiced law for a while. So they have some understanding at least of what it's like to be a lawyer with clients and argue in court and things like that. They have some understanding of that, as opposed to being sort of pure judges who've never made an argument really or had to try. So I think that's good actually. But what else? Anything else?
What do you think about this situation when judges, attorneys, prosecutors meet regularly in a sport events to play basketball together and then go to pub for a beer every week? Is it possible in the United States or prohibited or depends?
So there are some people, and there have been some state court judicial opinions, right, that have said that too close a relationship between a judge and a lawyer who regularly practices in the judge's court is unwise and should disqualify the judge anytime that lawyer comes to the court. I think it is tolerated more than it is in other countries, in part because this idea that we all went to law school together and we came out and we all were lawyers. Some of us then decided to be professors. Some of us then decided to be judges. Some of us then decided to be prosecutors. So it's not at all uncommon for even the judge's former law firm to be in that judge's court, right? I mean, it happens with some frequency, and it is not usually thought of as inappropriate for the judge to do that. At the other end of the spectrum, there was a decision, which I hope is going to be taken back sometime soon, in the Florida Judicial Conduct Board, or whatever they call theirs, that has ruled that a judge cannot be a Facebook friend with a lawyer who comes to the judge's court. And for me, at least, you guys know this maybe better than I do because I'm old, but I think this is an example of old people who don't understand technology or social media making rulings that they don't really understand. Because a lot of people have Facebook friends and they're not really friends, right? I mean, some of our Facebook friends are true friends, and a lot of them are not. I mean, I don't know about any of you. Do you have any people that are? I don't mean they're enemies so much, because you just don't know them that well, right? So I don't think it's such a close relationship that would be really questioned, in my mind, the relationship between them. Historically, it's been true that judges and lawyers in their courts belong to the same clubs, they belong to the same churches, things like that. So it's only the really close relationship that we usually say the judge has to be disqualified from.
My question was because it's very tolerated here in my country.
Oh, very much tolerated?
Yeah.
Okay.
It's not problem. Usually they say in district town, it's impossible for lawyers not to meet regularly because they were friends before.
Yeah.
So I can understand. I know that there is nothing wrong. You don't discuss the cases
right.
and this,
right.
But from the side of the public and from the side of trust for the judiciary, I don't think there is no problem. So
yeah.
it's something which needs to be discussed
yeah.
and to find some limit.
Yeah, there has to be some limitation, some sort of standard for deciding when the relationship is so close.
Yeah.
And that's the key, I think, is figuring out when the relationship is so close that the judge should disqualify herself from a particular case. It's not an easy thing to put into words, I suppose. But that seems to me to be the challenge, because we also don't want judges that are not allowed to have social lives. You know, I think it creates,
More problems.
yeah, judges who are not very good at understanding human relationships if they're not allowed to have any. And it's natural for them to have some with lawyers. I mean, they did go to school together, they did things like that, so it's pretty natural. Anything else anybody want to talk about?
May
Yeah.
I ask? It's probably more a general question, maybe also a historical question.
Okay.
Was the reason that in the United States never some more European-like model has been adapted of this period of schooling of young lawyers into the professions?
You mean having it be a graduate degree, a JD degree, or some other?
After the school.
Oh, after school, after you're already a lawyer?
Yes, through bars and professional.
We've all continuing legal education?
No.
No.
I mean this.
Oh, like the
preparation.
internship.
Yeah.
Like the internship, right?
There is such a tendencies in the I don't know, in
Yeah,
the
there-
19th century.
So I was saying this morning, but you've already forgotten that lecture, not surprisingly, that at one time, that's how all lawyers became lawyers, by being an apprentice to somebody, right? You know, not with, and without any formal education at all at one time. It was all that way. When the formal education came in the late 1800s, and this really big break with the profession occurred, I think that moment has destroyed for now more than 100 years anybody's serious thinking about having law graduates who, after all, go through a graduate degree, don't have an LLB, but they don't have a bachelor's degree in law, they have a graduate degree in law. Having them go to apprentice with lawyers, I think, would have been the last thing on earth that the people who reformed American legal education in the 1890s would have wanted to happen. They wanted them to be as separate as possible, as strange as that might sound sometimes. And so we've never gotten to the point where there was serious conversation about doing what you do in Europe, or for that matter in the UK, in Canada, in Australia, where they do what they call articling, which is functionally another form of internship after your formal education, where you have to go find a lawyer to sit with and work for a period of time at very low wage, usually. So I think we'll never get back to that. However, the closest we've gotten has been in the last maybe 5 years, since the economic crisis and the significant downturn in the number of law firm jobs that are available for graduates of law schools. And they're not going to come back. That part's not going to come back when the economy does. They'll find other kinds of jobs, but not big law firm jobs the way they used to. In this period of time, there have been people who have been calling for legal education to be less expensive and for it to only be 2 years instead of 3 years in the US. 2 years of a graduate degree instead of 3. Every single person except one who has suggested that publicly, there have been a lot of people suggested publicly, have said, and then the 3rd year could be used in some kind of apprenticeship. The 3rd year could be used in some kind of training program conducted by the state that is practical in some way. So I guess this is the most intense talk about it that there's been for 130 years. But I do think it was the break from the profession that happened in the late 1800s that kind of took that conversation completely off of the table.
Okay. I was thinking about that just because this reform of the law schools or a new start of American law schools was probably inspired from Europe, I guess, or from England.
I'm sorry, what was inspired?
Was this tendency towards more theoretical education in law inspired from Europe?
I think not. I think not. You mean the 1800s, late
Yeah,
1800s break. I haven't found any evidence of that. It was at a time of what came to be called scientification of the professions. And the professions at that time were not entirely respectable things to teach at great universities. They were thought of as a little bit too close to trade. There's a great line, which sounds silly today, from a contemporary during that period that said, a university should no more have a school of law than a school of dance. And at the time, that was thought to be, that made sense to people. Today, it sounds weird to us to say, but it was sort of like saying, dance, that's, what do you mean? That's just how to do something. What are you talking about? It's not science, for sure. Right? It's as far from science as we can imagine. Everything needs to be science. The people who reformed American legal education did two things that were very important to make it a respectable subject of study at great American universities. First, they made an argument that tried to ally law study with hard sciences, things like mathematics and biology. And they actually created, anybody ever do any biology study? So, I don't know if you've ever seen a biological chart where they have the species and genus and this category and that, what I'm talking about? Those kind of things where, so the first people studying, trying to make law into a science, made those for law. And they were contracts, torts, property, criminal law. That's what they did. And then they made all of these like crazy branches from them that were topics, basically. And they made it looked exactly like a biology chart. They did that in part to try to be respectable enough to have universities take them. And the second thing they did was, and in that process, they said that the library, and it's a common law system, of course, but the library is the laboratory. It is the laboratory for the law, right? You can go and read the data, the court decisions, the decided opinions of courts. That is the data upon which the law is created for you to understand. So they went out of their way doing that. And part of the distancing themselves from the profession was a way of trying to be more respectable for the university itself. And in law, unlike medicine, law had no connection to philanthropy of any serious kind or to government support. So even in those days, there was a lot of philanthropy for medical study, right? Trying to cure people of illnesses and diseases and things like that. And there was a lot of government spending even then. Now we have a lot more, of course. But even then, we had a lot of government support for medical science and medical study and medical testing and things like that. Neither of those two things existed for law, right? And the consequence was that the method of instruction sought to have one professor and 100 students, rather than one teacher and 20 students or 10 students, or which most other graduate programs had at the time. So I think it wasn't inspired by Europe. I think it was a unique combination of kind of social, economic, and cultural phenomena that happened at the same time. Okay, it's a beautiful day. Let's go. You're tired, I'm tired. I will see you tomorrow. Well, I may see some of you at the...
At 5.
At 5 o'clock. But I will certainly see you tomorrow at 9.
At 9, again here.
I think it's here, I don't know.
Yeah.
I don't know. Okay, thanks. See you then.
Thanks.
You bet.